have admitted they're authored by former law clerks of Judge Barrett's.
Without objection.
I'd encourage all of my colleagues to read them. They're outstanding and provide great insight into Judge Barrett's immense qualifications. Judge Barrett, moments ago, we went through a rather interesting set of exchanges. One of my colleagues, I hope I misunderstood him, seems to have suggested that it's a political talking point for you to decline to indicate how you would rule on a particular case or a particular type of case. To the extent that that's what any colleague has suggested, I'd remind that colleague that's just wildly incorrect. It's wildly incorrect with canons of judicial ethics, with federal law, with the statement laid out by Justice Ruth Bader Ginsburg in her own confirmation proceedings before this very body in this very room nearly 30 years ago. It is imperative that you uphold those standards, and I applaud you for doing so. And I think on no planet is it appropriate for anybody to suggest that that's a political talking point for you to say, I'm not going to indicate how I'm going to rule in a particular case. Justice Ginsburg did, in fact, say it well, and some of this has been quoted today. I'm going to quote it again just for good measure. She said, judges in our system are bound to decide concrete cases, not abstract issues. A judge sworn to decide impartially can offer no forecast, no hints, for that would show not only disregard for the specifics of a particular case, it would display disdain for the entire judicial process. Similarly, because you are considering my capacity for independent judging, my personal views on how I would vote on a publicly debated issue were I in your shoes, were I a legislator, are not what you will be closely examining. That's what she said. She said it well. It was true in 1993, and it remains true today. I want to turn next to a line of questioning that you just finished, that you just completed. I, too, have read the Cantor case, and I am thrilled that we've got a jurist who is willing, when looking at somebody whose constitutional rights are about to be taken away, thrilled to have a jurist who's willing to consider a pre-deprivation review for that individual. Is it unusual, Judge Barrett, to consider someone's constitutional rights on an individualized basis before having a specifically enumerated, constitutionally protected right removed?
That would be very, very unusual.
It would be very, very unusual, and it would be unwise, would it not?
Well, I think what I could say to that, just to be careful about how much law I'm analyzing, is that the 14th Amendment Due Process Clause certainly guarantees to each individual due process before liberty is taken away.
I also appreciated the thorough analysis that you undertook, making clear that our rights in this area don't just date back a few decades. They don't just date back to the 60s. They don't date just back to the 1780s or the 1760s. They date back at least to the 1660s. I mean, they go way, way back. There's a lot of history that went into what became the Second Amendment. There were conflicts. This involved not just partisan conflicts, but conflicts between the king and subjects. And not just between the king and subjects in the abstract, but very often it was between Protestants and Catholics. Sometimes it was Catholics who weren't trusted with guns. Sometimes it was Protestants who weren't trusted with guns. But there was a lot of violence that went into that and that led to our adoption of that amendment. I appreciated your historical analysis of this, your willingness to be thorough, to make sure that when someone's constitutionally protected rights are taken into account, you're going to do your homework. You're going to do your homework even if it's hard. You're going to do it even if you've got colleagues who aren't willing to go there. That's what judicial leadership is. Judicial leadership involves willingness to stand alone. Judge Barrett, one of the things that came out to me as I read your opinion in the Cantor case is that your commitment to textualism and originalism are, in fact, real. They're not feigned. This is the kind of thing you can't fake. This isn't something you make up at the last minute. And yes, I agree with Senator Durbin. Being a textualist and originalist doesn't guarantee a particular result, a particular outcome in any particular case. but it does indicate a style, a preference. Tell me why textualism and originalism are important to you.
Because I think that both statutes and the Constitution are law. They derive their democratic legitimacy from the fact that they have been enacted in the case of statutes by the people's representatives, or in the case of the Constitution, through the Constitution-making process. And I, as a judge, have an obligation to respect and enforce only that law that the people themselves have embraced. As I was saying earlier, it's not the law of Amy, it's the law of the American people. And I think originalism and textualism, to me, boil down to that, to a commitment to the rule of law, to not disturbing or changing or updating or, adjusting in line with my own policy preferences what that law requires.
And is it the subjective motivation, the subjective intent of an individual lawmaker or drafter of a constitutional provision that we're looking at, or is it original public meaning? And if so, what's the difference between those two?
It's original public meaning, not the subjective intent of any particular drafter. So one thing I have told my students in constitutional law is that the question is not what would James Madison do. We're not controlled by how James Madison perceived any particular problem. That's because the law is what the people understand it to be, not what goes on in any individual legislator's mind. I respect you greatly, Senator Lee, but what you think in your mind rather than what passes through both houses and is signed by the president, that's what's the law, not any private intentions you have.
So regardless of what, let's say I pass Bill XYZ, and I'm the sponsor of it. I take it down to the floor, and I say, here's Bill XYZ, and here's what I think about it. Here's what I intend to do with it. And I put that statement into the legislative record. What, if any, impact should that statement have on the meaning of law XYZ once it becomes law?
Nothing. You got to get it into the law itself if you want it to be law. Legislative history is not what goes through the process of bicameralism and presentment.
Regardless of how passionately and persuasively I make that point in whatever glorious speech I give in support of Bill XYZ, it doesn't make a darn bit of difference, does it?
It doesn't. I'm sure the speech would be glorious, but I assume the point you make probably would be made by the advocates in the case, too. And so in that respect, you are functioning as an advocate when you make the glorious statement, but not speaking with the voice of the lawmaker, because no individual does. It's the full body that speaks.
I want to speak next about the Affordable Care Act. We've seen posters going up over and over and over again. We've seen them yesterday. We've seen them today. We've seen a lot of compelling stories about people whose lives have been marked by difficult things that they've endured. They've involved touching and heartwarming stories. I continue to doubt the relevance of things like that here, especially insofar as they're being used to suggest that your confirmation to the Supreme Court of the United States has anything to do with their health care. Tell me why you think that any individual American's health care status is or is not tied to your confirmation to the Supreme Court of the United States.
It is not tied to my nomination to the Supreme Court of the United States. I have said repeatedly under oath that I had no conversations with anyone in the White House about that case. And I'm not sure, to the extent there's a suggestion that I have an agenda that I want to strike down people's protection for pre-existing conditions. That's just not true. I've never taken that position, and as I've also said repeatedly, any policy preferences that I have don't matter anyway. They're irrelevant. So making that law, coming out with the contours of the ACA, that's your job.
It is our job. It is the job of policy-making branches of government. It's the job of whatever combination of state and federal lawmakers and other policymakers have. But a judge is not a policymaker. When Congress passes a law, Congress is in charge of making sure that that law works. Insofar as that doesn't work or that law ends up being stricken down, it's our job to replace it with something that does work, whether constitutionally or otherwise in all respects. That's our job, not yours. You made some comments a few years ago, comments with which I wholeheartedly agree. Raising a criticism with Chief Justice Roberts and his majority decision in NFIB versus Sebelius. A decision, and don't worry, I'm not going to ask you to weigh in on this. You made those comments at the time, and they're not relevant to me now, but I set this up for reasons I'll explain in a moment. He rewrote the Affordable Care Act, not just once, but twice, in substantive ways, in order to save that law from an otherwise inevitable finding of unconstitutionality, because that law, as written by this Congress, was in fact unconstitutional in two material respects at issue in NFIB versus Sebelius. Blatantly unconstitutional. He effectively acknowledged that the law, as written, couldn't pass constitutional muster. And so he rewrote it, not just once, but twice, in order to save it. That's water under the bridge. That happened. It's inexcusable that he did that. He misused the judicial authority. That case has absolutely nothing to do with California versus Texas. It has absolutely nothing to do with the question of severability in that case. Would it be fair to say that my very strong opinions that I've just expressed do not indicate how I would feel, how I would lean were I a jurist in California versus Texas?
I think you're correct, Senator Lee, that the question, the legal issue, is entirely different in California versus Texas. Severability is its own independent doctrine and has nothing to do with the statutory interpretation questions presented in Sebelius.
In many circumstances in this country, we see emotionally charged issues that boil for a long time. They can't always be resolved. Not everybody's going to agree on everything. Not everybody is going to agree on certain hot-button social issues that result in some cases from just basic differences in how people view life and how people view their place in the universe. One of those areas where it manifests itself is in the area of abortion. People view life and when it begins differently. Some of that's informed by religious beliefs. Some of it's informed just by people's common sense approach to what they think the law ought to say and what it ought not to say. Disputes regarding when life begins and disputes regarding abortion didn't begin with Roe versus Wade. What did change with Roe versus Wade, however, was the federalization and the grasping of the issue and the taking it beyond the realm of political debate within the federal judiciary, such that elected lawmakers were no longer in a position to be the primary drivers of policy. As a result, over the last few decades, you've had all kinds of questions that have been put into uncertainty. You've got uncertainty by people at the state level who want to make their own decisions about certain things around abortion. They know they can't prohibit it entirely. They know that there's this undue burden standard that has to be addressed. Nobody's completely sure in advance what that means, and so they work around it. There are discussions that arise regarding health and safety qualifications for abortion clinics, how close an abortion clinic needs to be to an accredited hospital, how it needs to be staffed, and what the sanitation protocols are. Then you've got, more recently, some states passing laws saying, look, there's abundant medical science showing that an unborn human can feel and respond to pain as early as, 10 or 12 gestational weeks, but certainly by 20 weeks. And so by 20 weeks, we're going to adopt a different set of legal procedures for an abortion as a result of that, because if this is a human that everybody agrees can feel and respond to pain, we ought to handle that differently. All of those things, the legitimacy of those laws, are thrown into the federal courts yet again all because those were made federal issues. Now, I want to be very clear. You'd have the impression from watching debates in circumstances like this one and in protests outside the Supreme Court of the United States, you'd have the impression that if Roe versus Wade didn't exist, that all of a sudden abortion would immediately become illegal in every state in America. That assumes a lot of facts not in evidence. In fact, that assumes a lot of things contrary to evidence. It is not the fact that it is simply not the case that the fate of health care in America turns on whether or not someone is confirmed to the Supreme Court of the United States, nor is it a fact to suggest that the availability of an abortion or lack thereof is contingent upon anyone's confirmation to the Supreme Court of the United States. The fact that we have this debate and the fact that it's become as protracted, as personal, as ugly as it has, could, I suspect, be traced to the fact that we've tried to take a debatable matter beyond debate. And we've tried to take it outside the political branches of government where people can elect their individual representatives and have laws respecting and reflecting the views of their respective communities. We're a country of, 330 million Americans. It's really, really difficult to have those 330 million Americans reflected in 9 members of the Supreme Court. It's still really hard to have them reflected in 100 senators and 435 representatives. That's doable, especially when those people are elected. They stand for election every couple of years in the case of the House, every 6 years in the case of the Senate. It doesn't happen that way in the Supreme Court of the United States. So to my colleagues on the other side of the aisle, who are fear-mongering on this, causing people to worry and lose sleep over this, fundraising over this, fundraising over threats that people are going to lose their health care, fundraising over threats that people are going to be dying in the streets because of the lack of availability of this or that medical procedure. I'd ask, have we created a monster? Have we ourselves, through our own inaction, through our own voluntary cessation of authority to a non-legislative, non-political branch, have we created the very set of untenable social circumstances that are causing people to protest outside of a non-political entity? I think we have to ask ourselves that question from time to time. Life is, in fact, valuable. It's not a religious statement to make that observation. In fact, it's the foundation of basically all of our laws, not just in this country, not just in countries with Christian origins, but in basically every country that has ever existed anywhere in the world. The purpose of government is to protect life. That's what it's about. If we can't agree on the fact that it's reasonable that people ought to be able to have some say, at least at some limit, at least at some point beyond the moment when an unborn human can feel and respond to pain, something's wrong with us. And if we're going to leave those things perpetually in the hands of the unelected, it might be really convenient for political fundraising within Congress, but it's not good for the United States of America. It's not good for constitutionally limited government. It's not good for our individual liberties. Judge Barrett, Alexander Hamilton was prescient in a number of areas. He had some crazy ideas. He did some crazy things. He was also freaking brilliant. I think he foresaw certain aspects of our lives when he described the differences between the branches of government in Federalist 78. And in Federalist 78, he said that the legislative branch, Congress, being a political branch, a branch whose job it is to make policy, to make law, is possessed with will, and that what's possessed by the judicial branch is not will, but judgment. He then went on to explain that it's really important to maintain that that clear distinction between will and judgment, lest you have the judicial branch consisting of people who are not elected by the people, not accountable to the people at the regular intervals, and who serve basically for the rest of their lives so long as they're on good behavior. You can't have them exercising will because it's not their job. What do you think he meant? What's the difference between will and judgment?
I think will is the imposition of policy preferences as happens in the making of law. Judgment is evaluating that law for its consistency with the Constitution, for example, or, to give another example, to interpret what that law means. But it most certainly is not the imposition of policy preferences. A judge who approaches a case as an opportunity for an exercise of will has betrayed her judicial duty.
How does she know when she's reached that point?
So I think it requires disciplined judicial decision-making. So you approach the text, you treat it as a text, you treat it as law. You know, I've described originalism and textualism, so I won't belabor that point. But I will say that one practice that I have, one check that I put on myself to make sure that I'm not biased, is that when I write an opinion, I try to read it from the perspective of the losing party, so that any sympathy that I might feel for the particular result that I reach, I try to make the sympathy run the other way to see if it will still hold, and also to see, like, you know, I would be disappointed in this outcome if it was my child whose sentence or criminal conviction or civil loss, whatever it is on the line, but would I still think it was a well-reasoned opinion? And that's the test that I use for myself. I think discipline is required, but I take it very, very seriously.
As we've had this conversation today, one of the arguments that's been made by some of my colleagues is referred to activism, and has accused, if I understood the argument correctly, some textualist, originalist jurists as having engaged in activism. Now, I want to be clear. I'm one who doesn't believe that there is anything worse about an activist judge than a pacifist judge. Meaning, I think it's every bit as bad to be a pacifist. That is, for example, to let stand an invalid unconstitutional law as if it were valid and constitutional. It's every bit as bad to do that as it is to invalidate as unconstitutional something that is, in fact, not unconstitutional. Would you agree with me that both of those are equally instances of bad judging?
They are both instances, as you've posed them, of not following the law, of not following the Constitution, or not correctly interpreting a statute.
By the same token, a judge who fails to grant a meritorious dispositive motion and a judge who grants a non-meritorious dispositive motion. They've both probably done an equally bad thing. Is that right?
Yeah.
Does the Constitution say anything about the size of the Supreme Court?
The Constitution does not. That is a question left open to Congress. It's my understanding that it's been 9 for about 150 years, but that's as a matter of statute, not constitutional requirement. So
it's statutory. It's a statutory decision, one that stood for more than a century and a half. It's a decision, nonetheless, that has some bearing, could have some bearing on constitutional issues, correct?
Insofar as there would be more decision makers on the court?
If we abandoned the longstanding historical practice and tradition of having 9 justices, could that have an impact on the way the 3 branches of government interact with each other?
Possibly, but it's difficult for me to imagine what specific constitutional question you're asking. And of course, if there were one, I couldn't opine on it.
Of course. There are strong reasons, I believe, why over the last more than a century and a half we've left that number at 9. As you point out, there's nothing in the Constitution that requires it. We could come up with any number we wanted. There does have to be a Supreme Court and such inferior courts as we choose to create, but it doesn't specify the number of seats that can be on there. There are nonetheless good prudential reasons having to do with respect for the separation of powers between the 3 branches of government, reasons that have, over the last 150-plus years, left us to leave that number at 9. The last time, as far as I can tell, there was any serious effort to move the number above 9 was in the fall of 1936, when President Franklin D. Roosevelt got tired of this so-called 4 horsemen of the apocalypse, a few members of the Supreme Court who were consistently voting against his agenda, and sometimes joined by 1 or more other members of the Supreme Court. He got particularly tired of this, and so he proposed packing the court. And let me explain what I mean by packing the court here. What I mean when I refer to this is increasing the number of seats on the Supreme Court, and doing so by statute with the intent of altering the composition of the court for short-term political gain. That's what FDR wanted to do. Notwithstanding the fact that he had an overwhelming supermajority in both houses of Congress, fortunately, FDR's idea that he pushed in the fall of 1936 didn't make it anywhere. It didn't gain progress. It met enough opposition, even with both houses of Congress being overwhelmingly controlled by his political party, that it stalled quite mercifully. And it's remained ever since then at 9 justices. I think it would have been a colossal mistake. Joe Biden himself, as a U.S. Senator, as a member of this body, in a proceeding of this committee in 1983, gave a rousing speech that I recommend to all, talking about that very thing, acknowledging that the Constitution doesn't require it, but our respect for the separation of powers really ought to lead to us sticking to the number 9. Don't pack the court. In recent days, I've seen some in the media and some in this body try to redefine what it means to pack the court. Some have suggested, well, court packing takes various forms, and it can mean confirming a lot of people all at once. Some have defined it so as to suggest that it consists of doing that which the Trump administration and the Republican Senate have been doing over the last 3.5 years, which is filling vacancies as they have arisen, and doing so with textualist, originalist judges. This may not be something that some like, but this is not court packing. Court packing is itself manipulative. It's something that has great danger to do immense political and constitutional harm to our system of government, in part because it would set up a one-way ratchet. Once you create a position and confirm someone to that position, absent death, retirement, or impeachment and removal, that position remains in place. So, if, for example, a future Congress and White House were to decide to get together and to pack the court and increase the number, say, to 11, and let's say it's Democrats who do that, and we've got Joe Biden now as a presidential candidate who's refusing to say whether he would do it. There's a reason he's not saying whether he would do it. There's only one reason why you refuse to answer that question, and it's if you're wanting to be able to do it, but you don't want to take the heat for the fact that you're thinking about doing it right now. So if they do that, where does it lead? Well, it inevitably leads to the point where the next time Republicans have control of both houses of Congress and the White House, they'd increase it as well. You'd end up increasing it incrementally. Before long, it looks like the Senate in Star Wars, where you've got hundreds of people on there. I don't know what the total number would be, but you increase it at all, you change the number at all, you do so for partisan political purposes at all, you delegitimize the court. And you can't delegitimize the court without fundamentally threatening and eroding and impairing some of our most valued liberties. You can't do that without inevitably threatening things like religious freedom. Things like free speech. Things that are themselves often unpopular, but are protected by the Constitution precisely because they are unpopular. And yes, in that respect, the Constitution is sometimes counter-democratic. Sometimes it can be described as fundamentally undemocratic. In fact, it's the whole reason to have a Constitution, is to protect us from the impulse of a majority that might be bent on harming the few in the name of the many. That's why the law is so important. That's why the position for which you're being considered is so essential. That's why we've got to do our job to make sure that the only people who get the job for which you've been nominated fit the bill. You, Judge Barrett, are someone in whom I have immense confidence, immense trust, and I look forward to voting, to confirming you for that very position.
Thanks, Senator Lee. Let's come back at 12:45. We'll start with Senator Whitehouse. We have 15 senators left. Everybody takes the 30 minutes, 7.5 hours. We'll take a break for dinner tonight, sometime later on, and a short break. Are you doing okay? 3 hours about right? So we'll come back at 12:45, and right now we're on schedule to be here to 9 o'clock, but we'll do whatever the committee wants. We're in recess to 12:45.
All right, so you're here. They're taking about a 40-minute break.